Imagine you're like a corporate manager, right?
Okay.
And you've just hit every single one of your company's inclusion targets for the year.
Right. Which usually means a good year.
Exactly. I mean, 10 years ago, you'd get a promotion.
Yeah.
But today, hitting those exact same targets might just trigger a federal subpoena or even a multi-million-dollar reverse discrimination lawsuit.
Yeah. It is a complete inversion of how human resources departments have operated for, well, the last decade.
It really is.
This standard playbook for corporate compliance isn't just outdated right now. It's actively creating massive legal liabilities.
And that is exactly our mission for this deep dive. Welcome in, everyone. Today, we're unpacking a really rapidly shifting, highly polarized global debate.
Yeah, it's a big one.
It's the collision between workplace diversity initiatives and these rising allegations of anti-white racism. What we're really looking at here is, a story about corporate self-preservation versus individual rights. And to do this, we're pulling from a stack of fresh sources. We have an incredibly detailed article by Gary Pynchon. It covers recent global government actions and multi-million-dollar corporate lawsuits,
Along with some really solid background materials from the Australian workplace discrimination representatives.
Right, they go by AWDR, which is a specialized workplace relations firm. But before we get into the weeds here, I need to make something very clear to you, the listener.
Yes, very important context.
Because our sources today cover highly politically charged policies from both left-wing and right-wing perspectives, we want to be absolutely clear. We are not taking sides, nor are we endorsing these viewpoints. Our goal is strictly to impartially report the facts and ideas exactly as they are presented in the source material, so you can understand the changing landscape.
Which is just crucial right now because the legal mechanisms governing how you get hired, promoted, or fired, they're being rewritten as we speak.
Yeah, literally right now.
Exactly. And if you want to understand how a global standard gets flipped upside down, we really need to look at the mechanics of the enforcement.
So let's start with a regulatory environment is shifting the most aggressively right now, which is the United States.
Right.
Following the November 2024 election, the incoming Trump administration initiated this sweeping top-down dismantling of traditional workplace policy.
Yeah. They are framing diversity, equity, and inclusion DEI not as a tool for fairness, but as a mechanism that they argue has actually created systemic anti-white racism.
Wow.
So starting in early 2025, the administration didn't just issue guidelines. They used executive authority to order all U.S. federal agencies to completely shut down their internal DEI programs.
Just totally gone.
Gone. They abolished equity-related government grants entirely.
And it extends into the private sector too, right?
Oh, absolutely.
Because they mandated that federal contractors have to legally certify they are not engaging in DEI programs. And they tasked the Department of Justice with, identifying and investigating the most prominent DEI practitioners in major publicly traded corporations.
Right. Which brings us to early 2026 and this massive probe into Nike by the U.S. Equal Employment Opportunity Commission.
The EEOC.
Exactly. And the role reversal here is what makes this so historically significant.
How so?
Well, traditionally, the EEOC investigates discrimination against minority groups. But under the current leadership of Chair Andrea Lucas, who is a Trump appointee, the agency has adopted this strict colorblind enforcement mechanism.
Okay.
So they are actively investigating whether Nike's diversity initiatives resulted in intentional discrimination against white employees and applicants.
Okay, so let's look at the specifics of what Nike actually did. Because back in 2021, Nike set what they called their 2025 targets.
Right.
They publicly stated they wanted 45% representation of racial and ethnic minorities in their U.S. corporate workforce and 35% representation at the director level and above.
Which at the time was a pretty standard corporate goal.
Right. And now, Nike's defense is that these are simply, quote, good faith targets to broaden recruitment. But I have to ask, it sounds like setting a strict speed limit but telling drivers it's just a suggestion.
Yeah.
At what point does a corporate target legally cross the line into an illegal quota?
And that is the exact legal wedge the EEOC is driving into this case. I mean, how do you differentiate a soft goal from a hard quota?
Right.
The EEOC looks at the underlying financial incentives and the enforcement mechanisms within the company itself.
Like bonuses and stuff.
Precisely. They investigate whether executive bonuses or, say, a middle manager's financial compensation were tied to achieving these specific demographic percentages.
Oh, I see. Because if a manager's year-end bonus shrinks because they didn't hire enough people of a certain demographic, They are financially incentivized to make race a deciding factor.
Exactly. If compensation depends on hitting a target, the EEOC views that as a hard quota,
Wow.
which pressures managers to factor race into their employment decisions. And under the U.S. Civil Rights Act, that is a direct violation.
And the crazy part is, the EEOC isn't just looking at new hires here.
No, they're going way back.
Right. They're demanding records going all the way back to 2018. They want to see if white workers were systematically overlooked for promotions, or even worse, during recent workforce reductions, if white employees were disproportionately targeted for layoffs simply to protect those diversity numbers.
Yeah.
I mean, Nike is calling the subpoena an impermissible fishing expedition, but the government is doubling down.
They really are. And to understand the changing philosophy at the top, you just have to look at the public messaging. In December 2025, EEOC Chair Andrea Lucas posted a video on X, formerly Twitter, inviting any white male who has experienced workplace racism to file a complaint directly with the agency.
Wait, that was right after she interacted with Vice President J.D. Vance on the platform, right?
Yes, exactly.
Because he had called DEI an immoral and deliberate program of discrimination primarily against white men.
Yeah, and Lucas responded, agreed with him, and declared that, quote, the gaslighting ends now.
Oh, wow.
So by turning her social media into a direct intake portal for reverse discrimination claims, she signaled a massive shift in how the federal government views the burden of proof in the workplace.
So the focus is squarely on enforcing a strictly colorblind standard.
Exactly.
Okay, so the U.S. is essentially trying to enforce this colorblind legal universe right now. But if we pivot and look across the Pacific to Australia, they're operating under a completely different legal philosophy.
Total opposite end of the spectrum.
Right. The Australian government is looking at the workplace explicitly through the lens of historical race and power.
Yeah, the contrast is fascinating because the underlying assumptions are totally opposite here. The Australian Human Rights Commission, the EHRC, they draw a very deliberate line between individual racial prejudice and systemic racism.
Okay.
The current race discrimination commissioner, Gridharan Sivaraman, argues that Australian institutions were fundamentally, quote, built to ensure white privilege and white supremacy.
Yeah, he actually laid this out in an opinion piece in early 2025.
He did.
He stated that the education system is built for white knowledge and that Australian workplaces elevate white people into leadership by default. So, according to his framework, white Australians cannot experience systemic racism because they inherently hold this unearned advantage.
Right. And because the AHRC holds that viewpoint, they don't view policies like their national anti-racism framework as reverse racism.
What do they call it?
They classify them as necessary corrective actions. The logic is that if the system is inherently tilted, well, you have to actively tilt it back to achieve neutrality.
And we are seeing this philosophy applied in real mandatory workplace environments.
Yeah, definitely.
Like, let's look at the Victorian Department of Justice and Community Safety, the DJCS. In 2024, they rolled out a cultural awareness program featuring a module centered entirely on the concept of white privilege.
Right. This was developed alongside the University of Melbourne. It was tied to the Victorian government's preparation for the statewide Treaty Act 2025.
Okay.
The department argued this training was a necessary step to ensure a culturally safe workplace for Aboriginal Victorians.
Was it mandatory?
Well, the broader cultural safety training was mandatory for staff, though they did make the specific white privilege module voluntary.
Okay, but voluntary or not, the political backlash was immediate.
Oh, massive backlash.
Critics like John Story from the Institute of Public Affairs argued it seeks to divide the community by race.
Right.
Brian Marlow from the Australian Taxpayers Alliance criticized the use of public funds for what he termed far-left courses. The state opposition labeled it a woke agenda and promised to scrap it entirely if elected.
Yeah, it was a firestorm.
Even the officials defending it seemed to realize they stepped on a landmine. Corrections Minister Enver Erdogan actually admitted that the module probably could have been rebranded.
Yeah, the controversy really centers on the language and the framing.
Okay, let me pause and ask for some clarification here, because this is where the legal reality gets a bit confusing for me.
Sure.
If the AHRC is actively stating that white people have an unearned advantage that needs correcting, how does that actually square with Australian law? Doesn't the Racial Discrimination Act of 1975 protect everyone equally?
And that right there is the pivotal question. It highlights the exact tension between a systemic sociological philosophy and individual employment law.
Okay.
You are entirely correct. Under the Racial Discrimination Act of 1975 and the Fair Work Act of 2009, Every single person in Australia is strictly equal before the law, regardless of their racial background.
So an employer can't just fire a white employee or, like, deny them a promotion just to balance out historical inequities.
Absolutely not. An employer cannot legally use race as a basis for an adverse employment decision against a white employee any more than they could against a minority employee.
Wow, okay.
The law does not permit corrective firings. So the debate we are seeing in Victoria isn't about changing the law to allow discrimination.
And what's it about that?
It's about how workplace culture, training programs, and recruitment strategies fit inside that strict legal framework without crossing the line into unlawful, actionable discrimination.
Got it. So Australia and the U.S. are practically living in alternate legal universes regarding how they view equity right now.
Completely.
But what happens when these abstract philosophies crash into actual HR decisions? Usually it's in the courtroom.
And that brings us right back to the core theme we talked about. Corporate self-preservation.
Yes.
Because when companies prioritize public relations or rigid diversity numbers over procedural fairness, they expose themselves to massive liability.
It really makes me think of, like, yanking the steering wheel on an icy road. A company sees a PR disaster ahead, they panic and overcorrect to avoid it, and they just end up spinning the car right into a multi-million-dollar ditch.
That is a perfect analogy.
Let's talk about the Starbucks case, because this perfectly illustrates the mechanics of how this happens. This resulted in a $28.3 million payout to a former regional director named Shannon Phillips.
Right, and to understand the mechanics of this lawsuit, we really have to go back to a massive corporate crisis in April 2018.
Okay.
2 black men were waiting for a business meeting in a Philadelphia Starbucks. They hadn't bought anything yet, and a store manager called 911. The men were arrested.
Oh, I remember the Philadelphia arrest. It was a massive story.
Huge. The video went viral, sparking nationwide protests. It was an unprecedented PR nightmare for the brand. Starbucks actually ended up closing 8,000 stores for a day of racial bias training.
But wait, how would closing stores for a day of bias training escalate into firing a white regional director who had been with the company for 13 years?
Well, according to her lawsuit, Starbucks was in full panic mode. They were so desperate to prove their commitment to racial equity to the public that human resources started seeking out white employees to punish.
Employees who had nothing to do with it.
Exactly. Employees who had absolutely nothing to do with the arrests. They needed scapegoats to show they were cleaning house.
So Starbucks HR orders Phillips to place a white district manager on administrative leave for alleged discriminatory conduct.
Right.
But Phillips looks at the facts and objects. She points out that this specific manager had been there 15 years, didn't even oversee the Philadelphia store where the arrests happened, and the allegations against him were factually incorrect.
And here is the smoking gun that Phillips presented in federal court.
What was it?
She pointed out that the actual manager of the store, who was black and who had promoted the employee who made the 911 call, faced 0 disciplinary action from the company.
Oh, wow. So there was a clear, documented racial double standard in how HR was responding to the crisis.
Exactly.
Phillips refuses to throw an innocent white manager under the bus. Less than a month later, Starbucks fires her. And the only explanation they give her is, quote, "The situation is not recoverable."
And the jury saw the mechanism clearly. During her federal trial, she proved that her race was a determinative factor in her dismissal.
Which is huge.
The jury awarded her $25 million in punitive damages, which is designed to severely punish the company for its conduct.
And the remaining $3.3 million.
That was made up of compensatory damages, back pay, and front pay.
Front pay.
Yeah, front pay is a crucial legal concept here. It is essentially the court compensating her for the future wages she'll lose because this unlawful firing derailed her entire career trajectory.
Wow.
It brought the total to over $28.3 million.
That is staggering. And Starbucks is an isolated incident. Look at Nofin Health.
Right, another big one.
A former senior vice president, David Duval, successfully argued he was dismissed purely so the company could meet his diversity goals by replacing him with a woman and a black man.
Yeah.
A jury initially awarded him $10 million, which was later adjusted by an appeals court to about $3.37 million in back and front pay.
Still a massive payout.
Absolutely. The underlying insight here is that HR departments aren't necessarily trying to engineer social justice. They are just trying to minimize corporate liability. But their methods are severely backfiring. Individual employment rights cannot be bypassed for corporate optics.
And because the legal landscape is so confusing right now, we are actually seeing an entirely new cottage industry pop up to help employees navigate this friction.
Right, which brings us to the resources mentioned in our sources. How does an everyday listener protect themselves if they get caught in the crossfire?
It's a great question.
The article highlights the Australian Workplace Discrimination Representatives, or AWDR. And to be clear, we aren't pitching them, but they serve as a perfect example of how the free market is responding to this confusion.
Exactly. And it's important to clarify who they are. They are not a law firm, and they aren't lawyers giving legal advice.
Right.
They are workplace relations specialists. They have over 30 years of experience and have handled over 16,000 clients.
Wow.
Yeah. They operate with a self-described social justice agenda, offering no-win, no-fee representation for everyday employees facing a spectrum of workplace issues.
The sources mention they handle unfair dismissals, toxic workplaces, serious misconduct, and general protection disputes. What exactly is a general protection dispute?
A general protection dispute essentially means claiming you were fired or punished for a discriminatory reason, like your race, gender, or age, or because you exercised a basic workplace right.
Like what?
Like questioning an HR directive you believed was unlawful, much like Shannon Phillips did.
Ah, okay. So if they aren't lawyers, how do they actually help an employee who is going up against a massive corporate HR department?
They focus on the mechanics of the dispute. If you face adverse action, they help you gather the relevant internal records. They help you identify the true legal extent of your claim and then provide strategic guidance to navigate the Fair Work Commission.
So they're kind of like guides.
Exactly. They handle the mediation and negotiation, essentially acting as specialized navigators for employees who feel totally overwhelmed by corporate compliance structures.
Which is a vital service, because taking on your own employer is incredibly intimidating.
Oh, absolutely terrifying for most people.
Let me pose a question to you, the listener. If you were called into a meeting tomorrow and told that your role was redundant, would you actually know if it was a genuine redundancy? Or would you wonder if you were being quietly pushed out to balance a corporate spreadsheet?
And that is the core takeaway here. Whether you are working in a country like the US that is actively dismantling DEI programs, or a country like Australia that is exploring systemic privilege training, your individual rights remain ironclad.
Good to know.
If you face adverse action, forced resignation, or unfair dismissal due to race, any race the law protects you, you don't have to be a legal expert because there are specialized representatives who understand the mechanisms and can guide you through the process of holding an employer accountable.
It is an immense amount of information to process. We are watching the fundamental rules of the modern workplace get rewritten in real time, and the financial stakes have never been higher.
And if we look at where this is heading next, the complexity is only going to increase.
How so?
Well, as companies get increasingly terrified of these multi-million-dollar lawsuits, they are turning to AI and algorithms to screen resumes and manage hiring.
Oh, to remove the human element.
Exactly. The goal is to completely remove human bias, but a massive question looms. How will these systems actually be programmed? Will the AI be instructed to be strictly colorblind to align with the new U.S. federal policy? Or will the algorithm be weighted to perform corrective actions like the Australian sociological model suggests?
Wow.
The next battleground for workplace equity might not be in the human resources department at all. It might be buried in the code itself.
Wow. So those harmless corporate buzzwords aren't just legal tripwires anymore. They are about to be hard-coded into the software that decides if your resume even gets seen.
It's a wild frontier.
Keep your eyes open and know your rights. Thank you for joining us on this incredibly complex deep dive. Stay curious, stay informed, and we will catch you on the next one.